Intellectual property creation and management for emerging growth technology companies. The Patent Cooperation Treaty, Part 1. This presentation is brought to you by the IP attorneys and professionals at HULSEY Intellectual Property Lawyers through the HULSEY Intellectual Property Technology and Invention Monitor website. HULSEY Intellectual Property Lawyers, IP professionals for entrepreneurship's new golden age. This presentation is part of the Technology and Invention Monitor website's Legal and Business Issues and Instructions resource. Intellectual property creation and management for emerging growth technology companies. The Patent Cooperation Treaty, Part 1. Let's begin the presentation.
Now we're going to go into more of a mechanical, hands-on type of analysis of a tool, the purpose of which is to provide a procedural mechanism for the establishment of substantive intellectual property, and particularly patent rights, from around the world based on or beginning with a single domestic filing for the United States, a single U.S. filing, which may be a provisional filing patent application or a regular utility patent application. I've broken up modules 4 and 5, one to talk about where we've been, where we're going with the Patent Cooperation Treaty, and then in module 5 we'll talk about some of the changes that occurred in the last couple of years relative to the Patent Cooperation Treaty and how it is even yet a further user-friendly tool for the establishment of international patent rights. Modules 6 and 7 deal with enforcement considerations, and we'll talk about those at the appropriate time. What I want to talk about with regard to the Patent Cooperation Treaty include a historical overview, how we got to the Patent Cooperation Treaty, the current status, some of the future projections of where we're seeing the Patent Cooperation Treaty go, and then as we go through modules 4 and 5, some of the new and not so new directions and considerations. How do we make this international tool a valuable, usable mechanism for the entire world, the establishment of a harmonized regime of patent protection in all countries that are WIPO or World Trade Organization countries. The Patent Cooperation Treaty was first established for use in June of 1978. During that year, there were 459 applications received by the different international offices that were signatory offices to the Patent Cooperation Treaty. The way this works is you identify the receiving office, and that could be the European Patent Office or the U.S. Patent and Trademark Office or other offices that are designated as receiving offices. Not all countries that are signatory countries to the Patent Cooperation Treaty are designated as receiving offices, only a subset of those. But those countries can do things such as searches, and we'll talk about the searches that take place under the Patent Cooperation Treaty, and can facilitate the examination as part of their duties as being receiving offices and searching and examining offices for the Patent Cooperation Treaty. But in 1978, there were 459 applications received by the various receiving offices. 19 applications were published. This was one of the first areas where we start seeing on an international scale the international publishing of patent applications through the processes administered by WIPO. There were 10 staff members at WIPO who had received or worked in administering the Patent Cooperation Treaty, and there were 118 contracting states. If you look at this map, what you see is most of the developed countries had, by January 2003, had become signatory countries. What you're seeing here, let's take a look at the map a little bit. You're seeing that some of South America a little bit of Central America, Africa, particularly the gaping hole. I have a client who I just filed a number of patent applications for, and the problem that we ran into with that client, the client had filed for patent protection in March of 2003. In March of 2003, my client filed a provisional patent application. In March of 2004, the client changed from a provisional to a regular utility filed in the United States, a domestic utility application filed in the United States, and then filed under the Patent Cooperation Treaty designating all participating countries in the Patent Cooperation Treaty. Well, my client's technology, very interesting technology. The technology has to do with the sensing of gravity. Why is that relevant? Well, the sensing of gravity for my client has to do with the ability, using technology, to use a gravity sensing device that can sense laterally as far as 500 yards in any direction, in any radial direction. Well, that technology, as you might understand, has attractive application in oil exploration. So I can send, using a borehole device, I can send his gravity sensor down a borehole that a oil rig has made down as far as the hole itself is. And if I'm not finding oil where I want to find oil, by virtue of sensing gravity differences that exist between the subsurface oil and the subsurface dirt, I can identify with the different gravity signals and signatures that my client's signature sensor can create within a range of as far as 500 meters in any direction. I can determine the presence of oil. Very attractive technology. Why is that relevant? Well, the problem that we dealt with was the fact that when it came time to go into the national stage of protection, which was 30 months after the original filing date of March of 2003, we weren't able to go into countries such as Saudi Arabia or such as Venezuela. Why? Because they weren't PCT countries. They had not been admitted to, they had not sought admission to the Patent Cooperation Treaty. And so in these countries that are valuable oil countries, oil exploration countries, I was not able to obtain patent protection for this oil sensing, gravity sensing technology in these countries. Now, what we're finding more and more is that the countries that previously were not, by virtue of GATT TRIPS, by virtue of becoming members of the World Trade Organization, and then also becoming signatory countries to the Patent Cooperation Treaty, we're making progress. But even yet today, Saudi Arabia, many of the Gulf states are not signatory countries to the Patent Cooperation Treaty. Venezuela is not a signatory country to the Patent Cooperation Treaty. So from a practical standpoint, if there is technology that would find its use in oil exploration, or technologies that would have particularly attractive use in these non-PCT signatory or non-PCT countries, from the very minute that you begin to seek protection, patent protection in these countries, you need to start thinking about whether or not that country in which a technology, an invention might have application is or is not a PCT signatory country. So in the next slides we look at some of the countries that are PCT countries. And so we're seeing most of the countries, Australia, Canada, France, Israel, Ireland, most of the developed countries that you would want to seek protection in. Some of the oil protection, Kazakhstan, some of these countries that are in fact important oil countries are PCT countries, but not all of them. You don't see in the second slide, you don't see Venezuela, you don't see Saudi Arabia, the Russian Federation certainly is. And so dealing and understanding with the Patent Cooperation Treaty. Another point to consider is the use of the regional patent offices. For example, the European Patent Office filing, a PCT filing in the European Patent Office will give you protection in the different European states. The Eurasian Patent Office will give you protection in Russia and the Baltic states that are signatory countries to the PCT, and going not only into the national stage by virtue of individual country filings, but also into the regional filings, and understanding which regional offices are signatory offices and have signatory countries into the PCT is an important consideration. Since 1970, the PCT has gone through 4 treaty certain administrative instructions, and about 200 PCT forms are used. That's another aspect of the PCT, is that it's rich in forms, it's rich in procedures that clearly facilitate the filing for international protection. Different regulations have evolved, guidelines for receiving offices. It's clear, it's a well-administered organization through the World Intellectual Property Organization that allows for international filing. But there's ongoing revision of agreements to further facilitate, and 2 separate bodies of agreements in 2003 and 2004, we'll talk about those, have been established for us to obtain international patent protection using the PCT. So where have we gone? Look at this. Growth of PCT filings, looking at 1978 rather, where we had the original 400 or 500 patent PCT filings. Just an exponential growth. In 2002, we've seen there were 114,000 international applications received. Of those filings over the years, we've seen about 50% of those were received in the years 1998 to 2000. About 25% of those received in 1993 to 1997. 11% in the 5 years from 88 to 92. Another 4-year window of 4.3% in 83 to 87, and then in the early stages of about 2%. Clear growth with a total of about 800 through 2002, and the numbers continue to increase of PCT filings that people are using and using effectively the procedure. Let's who's filing PCT applications? Well, Philips Electronics is filing all of their applications for protection in the United States and otherwise as PCT applications. And so from the very beginning, you're seeing that the international offices are dead. You know, one interesting thing about the PCT is that it provides, by virtue of its regulations, a defined process or timetable in which certain things such as searching, examination, reporting to applicants need to be addressed, as opposed to filing in the different domestic offices where people get to things when they get to things. Under the PCT, there are certain regulatory requirements that have to be satisfied, and one of the reasons that a lot of companies are pursuing PCT filings, even domestic filings originated as PCT filings, is the ability to use the more rigid timetables for correspondence between applicants. But Philips, Siemens, Bosch, a number of European countries, the Japanese have weighed in. Again, Nokia as a European country, 3M, the United States. All over the world, we're seeing increased numbers of filings for the PCT, and there are also filings in the developing countries, as in India, Korea, Canada, or China rather, and filings where the developing countries are becoming more and more attuned to and taking advantage of the PCT filings. One of the things that's occurred by virtue of the increased number of filings is a cost savings by streamlined procedures, by trying to make the PCT more of a user-friendly mechanism. In 1998, the typical cost for a PCT filing in terms of basic designation fees used to be on a per-country basis. You would be charged a certain, say, $150, $160 per country. As the time has progressed, we've moved away to that. Today, with one filing, you don't even designate countries any longer. There's a simple, straightforward PCT filing, and then all countries who are PCT signatory countries are immediately made available. So we started to see a stabilization in the cost for PCT filings. The average fee per application, again, has continued over the years to decrease from an original 1998 example of about $2,200 to about $1,600 per application. So we're seeing costs move down, but we're also seeing a continuing increase in the number of filings from, for example, the United States. We continue to grow at a pretty steady clip. Japanese filings are growing even yet faster, and European filings, so that it's not unrealistic. About 140,000 filings for 2005. That's a number that we've seen. And then as we move forward, we've continued to see increased growth in the PCT filings. So it's a viable mechanism for the pursuit, for the establishment of intellectual property rights. Now, what we've seen also is an impact of a new fee structure and the way of handling in comparison with the handling fee. Previously, it was discretionary, as I mentioned before, as to only payable at the Chapter 2 demand. Now we've moved forward, and it's a mandatory if you want to continue with the filing of the PCT. And in general, there's been a minor impact on the filing between the U.S. and the European. But as to the Japanese filings, the mandatory filing fee for all countries as opposed to individual countries has been more of a significant impact. Well, that's some of the mechanics, the introductory mechanics of the PCT. What we're going to talk about in this next module on the PCT are some of the changes that have occurred and how the PCT is a mechanism that is it's more user-friendly. It allows you to go into the national stage in a controlled manner and at the same time manage some of those fees, manage some of the accession into the national stage. In this module, then, we've talked about the history of the Patent Cooperation Treaty, how we have made the Patent Cooperation Treaty in many respects the primary mode to go from a domestic patent filing to an international filing. We've seen tremendous growth in the number of PCT filings over the years. We've talked about some of the economics in PCT filings, and then what we'll talk about in the next module, as I mentioned, are some of the considerations and changes that have occurred in the last couple of years.
This concludes the presentation. Thank you for viewing Intellectual Property Creation and Management for Emerging Growth Technology Companies, the Patent Cooperation Treaty, Part 1. Be sure to visit us at www.HULSEYIPlaw.com. Hulsey Intellectual Property Lawyers, IP professionals for entrepreneurship's new golden age. This is Bill Hulsey.